Kamon man long slur ringkat bat kamay ma shong kya ka shong hag jinglong scam bat jingjek ba start ka jong pi. Katata haya kakali ban san ya kalintiyat ka jong pi. Kalaban long ka jong pi minta. Bok ya katata haya ha frang motors like korangi. Ne phone hunu number bala ay harum. Menteri rang baga jylla Conrad ki sangma ulong baki paj baga jylla kim dei ban Sngewthuh Bakla baga sorkar ka Khang ban ti mau ti Shyiap ha ka jylla. Ha ka jing shisha kam don satya ka jing Khang ya ka jing ti mau ti Shyiap henrai ki bale ya ka ni ka kam ki ha ban yo jingbet bat buat katkum ki kendon bala bo. Katkum karai ki yeng ka shari. Haba jubab halor ka jing ta ya ka ni ka mat haba ka yeng dor bar thawan ka bala wanra u emily ka nongkrem uba arden em pasaimot u Conrad ulong ba ki hab ban pan jingbit ban pen biang ya ka mining plan environmental clearance but ka pollution clearance but ki wei ki jingdan kam katkum ka mines and minerals development and regulation act shiajar khandai spa henry puhnyo ulong ba kani ka jinglong tara ya ka jaka ka de ka wei ka binta hagani ka jylla ka bakdup ya ka 6th schedule henry ka rai ka kashri ka de ka wei ka binta ulong ba ka sarkar kan thaulat ban pet La ne ban pension sur yaki kendon ga Meghalaya minor minerals concession rule ajar country.
Sir, in exercise of the powers conferred under Section 15 of the Mines and Mineral Development and Regulation Act 1957, Central Act number 67 of 1957, the Meghalaya Minor Minerals Concession Rules 2016 was notified by the state government. The need for notifying these rules arose on account of the judgment and order of the Honorable High Court of Meghalaya dated 30th June 2015 of WPC number 140 of 2014 titled Tangba M. Sangma versus State of Meghalaya and others, prohibiting all mining activities unless the following have been complied. Number one, consultation with the CEC, that's a Central Empowered Committee. Number two, drawing a comprehensive scheme for restoration of environment damaged on account of mining. Three, creating a fund for reclamation of environment in the interest of sustainable development and intergenerational equity, and for the purpose of rectifying the damage caused to the forest and environment. So there was a court ruling in this regard, sir. When the judgment in the aforesaid case was sought to be reviewed by certain aggrieved individuals, on the premise that for several generations the forefathers of petitioners have been carrying out quarrying of limestone and other stones on a small scale in Khasi and Jaintia Hills district of Meghalaya, and that stone quarrying has been the livelihood of their families for generations, and that the land tenure system in Khasi Hills district of Meghalaya is totally unique, where the land as well as minerals underneath belong to the landowner. The Honorable High Court of Meghalaya, however, disposed of the review petition through their judgment dated 14/10/2015, delivered by a 3-judge bench, review petition number 11/2015 in Balyasware and others versus Tangba M. Sangma, declining to modify their order, except clarifying that instead of securing clearance from the CEC, the applicants for mining lease would need to obtain clearance from the statutory agencies which is in place currently, vis-a-vis the state-level Environment Impact Assessment Authority, which has been notified under the provisions of the Environment Impact Assessment Notification 2006, as amended from time to time, which have been issued under the provisions of the Environment Protection Act 1986. In view of complete embargo placed on any form of mining of minor minerals in the state without due process of law by the Honorable High Court of Meghalaya in the aforesaid ruling, The state government, driven by the intent to open the avenues for mining the minor minerals in accordance with the applicable statutes, notified the Meghalaya Minor Minerals Concession Rules 2016 in exercise of powers conferred on it under Section 15 of Mines and Minerals Development and Regulation Act 1957. Because no exemption is provided under the provision of Mines and Minerals Development Regulation Act 1957 for traditional small-scale mining from the ambit of the Act, therefore the Meghalaya Minor Minerals Concession Rules 2016 also could not provide any exemption clause in respect of small-scale mining of sand, stone, and limestone in the traditional manner. Thus, there being no provision for exemption for traditional mining of sand, stone, etc., either under MMCR 2016 or under the MMDR Act 2057, the state government could not exempt their operation without any quarry permit or lease being granted under the provisions of the aforesaid Meghalaya Minor Minerals Concession Rule 2016. The latter rules necessitate preparation of mining plan, environmental clearance, pollution clearance under Air and Water Acts respectively, clearance by district council authorities, etc. In the meanwhile, a further judgment was issued by the Honorable High Court of Meghalaya dated 21st July 2017 through a division bench in Writ Appeal number 38 of 2017 in Foreign Trade Chamber of Commerce, Meghalaya and others versus State of Meghalaya, along with Writ Appeal number 39 of 2017, Khasi Jaintia Limestone Boulders, Stone Exporters and Miners versus State of Meghalaya. The Honorable High Court, by their aforesaid order, dismissed the prayer of the petitioners for transporting stone, boulders and limestone without the state insisting on procurement of transport challans Form H under Rule 26 of the MMCR 2016. Further, the notification of Ministry of Environment, Forest and Climate Change, Government of India, through a further Amendment to Environment Impact Assessment Notification 2006, issued under the provisions of subsection 3 of Section 3 of Environment Protection Act 1986, via notification dated 15th January 2016, has made it compulsory to secure environmental clearance for mining of minor minerals, which would include sand, stone, limestone of non-industrial use, etc., in lease areas of any size. The amended EIA notification 2016 prescribes a requirement of environmental clearance in respect of mining minor minerals for mining leases or quarry permits for areas below or equal to 5 hectares also, which needs to be granted by the SEIAA. Earlier, only mining leases of areas 5 hectares and above needed environmental clearance, but after this amendment was made, even areas below 5 hectares are now required to apply for these different permits. Of further importance is the judgment of the Honorable Supreme Court dated 3rd July 2019 in State of Meghalaya versus All Dimasa Students Union, Dima Hasao District Committee in Civil Appeal number 10720 of 2018. The Apex Court in the latter case has held that Mines and Minerals Development and Regulation Act 1957 is fully applicable in the 6 scheduled states, including Meghalaya, and any form of mining in Meghalaya and any other 6 scheduled states should be in conformity with aforesaid MMDR Act 1957. Insofar as sand is concerned, which too is a minor mineral, in addition to existing environment impact assessment notifications, the provisions of MMDR Act 1957 and the Triple MCR 2016, the Ministry of Environment, Forest and Climate Change, Government of India, in compliance with the order of the National Green Tribunal dated 4/9/2018, in OA number 173 of 2018, titled Sudarshan Das versus State of West Bengal, has issued Sustainable Sand Management Guidelines 2016 and Enforcement and Monitoring Guidelines for Sand Mining 2020, all of which are mandatory in their application to all states in the country. Accordingly, the government of Meghalaya too have adopted them by notification number FOR.cc/14/2019/2019/PT/4, dated 14th of April 2022. Sand being a minor mineral within the meaning of the Triple MCR 2016, its mining too is subjected to regulatory control as contained in the said rules and the MMDR Act 1957. In compliance with the orders of the Honorable Supreme Court dated 12/2/2012 in IA number 12-13 of 2011, in Special Leave Petition C number 19628 of 2009, in the matter titled Deepak Kumar versus State of Haryana and others, and the orders of Honorable NGT issued in this regard, the Ministry of Environment, Forest and Climate Change, Government of India, has issued Environmental Impact Assessment Notification wide SO 141 dated 15 January 2016, amending the EIA Notification 2006 as aforesaid, making it mandatory to obtain environmental clearance in respect of sand mining, irrespective of size of the mining lease area. Currently, to facilitate applying for sand mining, Rule 4 of Triple MCR 2016 has been amended by the state government via notification number MG 49/2011/PT2/72 dated 4th of July 2022. The rules as they stood prior to amendment had prohibited mining any form of minor minerals within a distance of 100 meters from any water body, which had prevented sand mining applicants from applying for quarry permit for river sand. In view of the current amendment, the applications for grant of mining lease or quarry permit for mining sands are entertainable, and applicants could be helped with grant of quarry permit for mining river sand. Therefore, in view of the extant court rulings, including those of the Honorable Supreme Court and the Honorable Meghalaya High Court, in interpretation of the Constitution of India and prevailing statutes relating to mining and environmental clearance, the existing laws on the matter which are in force in our state, perhaps no exemption could be made in favor of small-scale mining of sand, stones, and any other minor mineral forms from the operation of these statutes for the purpose of securing mining lease based on prior environmental clearance. However, all steps would be taken to expedite granting mining lease or quarry permits to applicants who approach the department for the same. The departmental staff would also be instructed to assist such individuals in helping them fill the relevant forms and explain them the procedure involved for applying for such permit. Sir, this is obviously a very exhaustive and a very technical reply, but it was important to give the background of what is happening and why these different rules and laws have come in. But to make it very, very simple for everybody to be able to understand. So number one, there is no ban in mining of stones, quarry, or even sand. There is no ban. So first thing I want to make it clear, nothing has been banned. Number two, the issue of ownership of the land and the statutory provisions for applying for a permit are completely two different subjects. There is no question of arguing on the fact that the land belongs to the landowners and what is beneath the land also belongs to them. But that is not being challenged by these statutory provisions. So therefore, everything is as per the 6th schedule provisions, it is there. But as I said, the statutory provisions for applying for a mining plan and other things has to be followed. And that again has been reiterated by the Supreme Court in one of the orders that I had read out earlier. So that's the second point I wanted to make, sir. And third point which I would like to make is that all of these activities that are being done are mainly being done to ensure that there is a balance, as mentioned by most of the members. There's a balance between economic livelihood as well as the environment, so that the protection can be given to the environment also. And at the same time, a procedure is there in place so that the mining activities and livelihood can continue. So therefore, sir, I think the first point is the most important, that this narrative or this thought process or this idea that everything has been stopped now is not correct. It has not been stopped. It is just that we have asked people to follow a procedure and apply for different applications and go for the different permissions that are required. As mentioned earlier, sir, the mining plan, the environmental clearance, and the pollution clearance. So therefore, anybody who applies, the process is followed, and the applications are assessed, and the permissions are given. So therefore, sir, there should not be any confusion that we have stopped mining, or we are not allowing, or we have banned anything, sir. So only the procedure has been put in place, and that also has been done because of the different notifications by Government of India and different court rulings from the High Court and Supreme Court, which I have already quoted in my reply earlier, sir. So that is very, very important to understand. I must at this point in time, sir, appreciate what the suggestions that have been given by the members, especially our member from Amlaram constituency. He has precisely hit the nail on the head, I should say. And the issues here is not about banning or mining or not allowing. The issue really is the process, the procedure. And I appreciate his concerns. And if there is anything that we need to work on and which should move forward, is how to make it easier for people to get the permit and give the training to the people on how to do it. So therefore, there is a way. It can be done. But the problem is that some of our miners are not economically that well. So therefore, they have challenges in terms of being able to come to the office or be able to apply online and so on and so forth. Sir. So the challenge, real challenge is that. Sir. So hence the procedure and the process has been identified. It must be followed because of the court cases and the different laws that have come out by Government of India. There is no question of diluting the ownership of the land or the 6th schedule. It remains. And there is no question of banning, but now we have to only work towards ensuring that wherever our miners are facing problems in terms of applying, and even after applying, if it takes too much of time, we will need to streamline the process. So therefore, sir, let me give an assurance to this House that I will personally go into this aspect of applications, figure out how we could use technology, figure out how we could allow the applications maybe to be done at the grassroots level, maybe somewhere where the trainings can be given at the block level also, at the district level also, so that our miners can easily apply and they are able to start their mining process again, sir. So I just wanted to make this clarification that the real issue is precisely what the honorable member has mentioned, our honorable member from Amlaram, that we need to streamline the procedures. Maybe there are certain complications in it, which, as I said, I will definitely personally look into and find ways and means in which we can make it easier for them to apply, simpler to apply, and give the training for them to apply so that they are able to process it. So these are the clarifications I would like to make so that all our members are aware of this, that we are striking a balance and there's no question of taking the livelihood away from the people. I myself am very, very concerned about these issues, and therefore we will definitely work towards streamlining things. But these are statutory provisions. These are provisions by the Supreme Court, provisions by the by the Government of India, which are provisions which we need to follow, and we can't bypass those provisions. But as I said, we will make efforts to make the process simpler. So with these clarification, I hope I'll be able to satisfy the different concerns of the different members. And with that, I'd like to resume.